Hi, my name is Yogya Bhatia and I am a legal intern at LEXIS and Company. Today I'll be talking about prosecutors in a criminal justice system. Crimes are considered a wrong against the society at large, in addition to it being a wrong against the individual. Due to this convention, the state participates in criminal trials representing the people of a state in their collective capacity against the person accused of an offense. In both civil law and common law countries, the prosecutors are the counsel for states in criminal trials. The extent of the powers of a prosecutor varies from a country to country, but the main function, which is to prosecute criminals in courts of law, is universal. The institution of prosecutor has generally been given lesser importance in the Indian legal system. The problem of the criminal justice system in India are often attributed to the lack of judicial manpower, inefficiencies of the investigation agencies of the police, and corruption. The prosecutors receive lesser attention despite being a core part of the administration of criminal justice. Faster trials, good rates of convictions are the hallmarks of a good prosecution system, and a strong prosecution mechanism plays a crucial part in establishing rule of law in society. Hence, it is necessary to bring vital reforms in the criminal laws of a country to make the prosecution system more efficient and fast. The Indian system of prosecution, appointment of prosecutors. Before the Code of Criminal Procedure was enacted in 1973, crimes were prosecuted by public prosecutors who were under the control of the police department and answered directly to the district superintendent of police. Since the enactment of the Code of Criminal Procedure, public prosecutors no longer function under the Department of the Police. An amendment was made in 2005 that allowed states to create a directorate of prosecution that will make all prosecutors of a particular state under the control of the directors except the Advocate General of the state. The public prosecutor and additional public prosecutors appointed by the state government for a district are to be selected from a panel of persons who are considered eligible to become prosecutors. This panel of persons is prepared by a district magistrate in consultation with the session judge. In many states, a regular cadre of prosecuting officers exists. The prosecutors in such a cadre are selected through examinations conducted by the public service commissions of a state, and they are promoted to the post of public prosecutor. The state government has the power to appoint public prosecutors and additional public prosecutors from such a cadre if eligible candidates exist. However, if no eligible candidates exist in the existing cadre of prosecutors, then the prosecutors are to be appointed from the panel of persons created by the district magistrate in consultation with the sessions judge. Role of prosecutors in the criminal justice system of India. In the Indian criminal justice system, the prosecution of offences in trials is preceded by the investigation of those particular offences by the police. There are other minor offences as well which are prosecuted by private parties. These are known as non-cognizable offences. Investigation of crimes is the domain of the police. For this purpose, the police have been given the power to arrest persons, search premises of the crime, seize documents or items related to the crime, and other varied powers provided in the Code of Criminal Procedure to aid in the investigation of a crime. It is a common assumption that the work of a prosecutor begins after the police is done with the investigation and the charge sheet is filed. Most judgments of various high courts and supreme courts have commented on the conduct of a prosecutor concerning trial and the ethics that a prosecutor should adhere to. These developments just induce a prosecutor to conduct herself like another judge in the court. A prosecutor is the centerpiece of all trials in a court and has an important role in justice delivery of the victims. Pre-trial. Obtaining an arrest warrant directed to one or more police officers under Section 70 of the Code of Criminal Procedure. Obtaining search warrant to search premises for collection of evidence and documents crucial to investigation under Section 93 of the Code of Criminal Procedure. The prosecutor also plays an advisory role in suggesting to the police regarding the feasibility of proceeding with the case. Obtaining custody of the accused for interrogation of the accused under Section 167 of the Code of Criminal Procedure. Commencing proceedings in court for declaring an accused proclaimed offender in case he is not traceable under Section 82 of the Code. Commencing proceedings for attachment of property of an absconded accused after the issue of proclamation under Section 83 of the Code of Criminal Procedure. During trial. The significance of the role of prosecutor in the trial is immense. In criminal jurisprudence, the accused is presumed to be innocent until proven guilty, and the prosecution has to prove the guilt of an accused beyond any reasonable doubt. The trial begins after a charge sheet is filed against the accused under Section 173, subsection 2 of the Code and cognizance of the offence of the taken by the court under Section 190 of the Code. The prosecutor is responsible for the efficient conduct of a trial from the stage of examination of witnesses to the delivery of judgment, and during the course he performs numerous amounts of functions. The prosecutor argues For an effective bail hearing of an accused, keeping in mind the probability of an accused to abscond, tamper, or destroy evidence and threaten witnesses. He conducts the examination in chief of the witness of the prosecution and cross examination of defense witnesses to move in the case in favor of conviction of accused. Thank you.